A short rebuttal of 2 minutes. I will address 4 short points. Firstly, Article 18 does deal with due process. Alongside the right to be heard, it also considers reasonable notice, meaning each party needs to be given reasonable notice to prepare for any procedural or arbitration. So under the same concept of due process, our claims stand. That brings me to my second point of the New York Convention, which I mentioned earlier. Even if it is reasonable and even if you view our claims as petty, the New York Convention, which we are both contracting parties to, has set a standard, and the standard is the compliance with the procedural rules that we have taken into consideration and express our intent. So either way, we are bound to the New York Convention, and we would not be able to have this award enforced if we were to deviate from that. 2 small factual points are the context of the word initiate in the contract. The next sentence in the same section 21 is after initiation, that arbitration shall be conducted under the rules of the CAM-CCBC, meaning the clear context of this term is the CAM-CCBC rules, and it's the first most natural interpretation. And lastly, if we turn to the assets of the financial situation of claimant, we see that the liquid assets don't amount to what claimant is trying to show, meaning the first row, which is the cash and cash equivalent, show a very detrimental situation on claimant, which again upholds the risk of claimant not being able to pay the award. Thank you.
I have one question since you're in rebuttal now. Did you consider case law or the books of one example, precedent, that really the claim was barred because in circumstances that are more or less similar to your case? Can you show one instance where a court, whether it's a court of law or an arbitration tribunal, that in such circumstances are barred?
Yes, sure, Mr. Chairman. In the case that I shortly mentioned earlier, it's an English arbitration, under the English Arbitration Act, which was dealt with in the court, and the court dismissed the claimant's claim that being 8 days late, at a 1-month time limit, shouldn't deny his approach to the court. But we see that the court has denied his claim, so there's no official precedent in international arbitration, but at least this is a guide in.
What year was the date?
In 1999.
So it's the Arbitration Act of 1996 probably,
yes.
Right?
Thank you.
The tribunal will now talk for 2 minutes. A short rebuttal for my colleague. Well, my colleague here mentions rules, that we should follow the rules. These are the rules of the CAM-CCBC rules. These are the rules that governs the arbitration, and therefore it should be followed. What the Honorable Tribunal should keep in mind in our mind is the parties' autonomy, or what the parties had in mind when they chose to prefer arbitration upon a national court. One of the things that are better in arbitration is that we can settle our dispute quickly, efficiently, and to have it just another bump on the road, so we can continue our business relationship. This is how we want to settle this dispute. Again, following. We're not sure what is the law is applicable here. We're not sure what standards to apply in the case at hand. What we should have in mind, what we should keep in mind, is the rationales for arbitration. Now, secondly, regarding the law governing the interpretation of Section 21, the dispute resolution. Well. You can see in Section 20, the choice of law, the law that governs the contract is the CISG. Section 21 is the part of the contract. Moreover, the CAM-CCBC has something called the recommended arbitration clause. The arbitration recommended clause of the CAM-CCBC apply the CAM-CCBC rules also on the interpretation of a dispute resolution clause. The fact that the parties deviated from that recommended clause means that they chose to apply the CISG on the contract and the CAM-CCBC only on the arbitration once it is commenced. So to conclude, my colleague here, respondent, is wrong both on facts and on law.
Let me
Thank you
give